Welcome to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law, or visit DeWittLaw.com. If you want to get your legal questions answered on this show, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. We are here every Sunday morning at 10 a.m. talking about Florida's legal issues and how they affect you. My name is Jon Bustecker, and across from me is Moe DeWitt of the DeWitt Law Firm. Moe, how are you this Sunday morning?
I'm doing fantastic. How are you, John?
Good, good. Were you on vacation?
Yeah, I was out in Wyoming last week.
Wyoming, wow.
Yeah, but we did pre-record the show, so the show was a new show for the listeners out there.
I wasn't going to tell anybody that, Moe, but you just spoiled the secret a little bit.
We can pull back the curtain a little bit.
All right, but Wyoming was fun.
Yeah, it was beautiful out there. I mean, from what I read, it was a scorcher back here in Florida with a 109-degree heat index, and it was about 65 out there. So.
It was a little warm here.
Yeah.
It still is a little warm,
Yeah.
and we're not even close to having summer being over yet.
Not yet. We got a little while.
Yeah. 65.
It's good to be back, though.
65 in Wyoming. I could go for some of that here in Florida.
Oh, yeah.
Yeah. So, all right, Moe. So you've been gone a little bit, you were on vacation, but I know you've been keeping up with the news.
Uh-huh.
Probably one of the biggest things that has happened in the legal community here in Florida is this alimony bill that got passed. We've talked about it a lot, but I want to talk about it some more.
Yeah. Well, now it's been signed by the governor,
Yes.
so now it is actually official.
Okay. So maybe explain to folks what exactly changed from June 30th to July 1st, because the law went into effect on July 1st. So what changed?
Right. So, I mean, the biggest thing under the alimony bill is that we eliminated permanent alimony. So now in Florida, we have 4 types of alimony. We have temporary alimony, which is basically alimony that you get kind of during a divorce case while the case is pending, so that you can pay bills or do whatever you need to do, basically maintain a similar to your lifestyle. So that's temporary alimony. Then we have bridge the gap alimony and rehabilitative alimony. And those are basically what they sound like. So bridge the gap is just kind of help you get back on your feet. It's going to be a shorter term alimony, help you do things like pay for a security deposit or put down a down payment to get a new place to live, have some spending money until you can kind of get back on your feet and start a new life.
Sounds a bit like a skateboarding trick. I'm not going to lie to you. When I hear bridge the gap, that's what I think of.
Well, I mean, in some context, some circles, sure.
Okay.
And this one, not so much.
All right.
And then we have rehabilitative alimony, which for rehabilitative alimony, usually that's where someone's going to go back and get some additional job training or go back to school. So you have to submit a rehabilitative plan for that. And that, again, would be a shorter term alimony, but it's basically, again, to kind of get some additional skills or something so that you can be self-supporting. And then the most common or I would say most common type of alimony going forward is going to be durational alimony. So durational alimony is just alimony for a duration, a specified period of time. And so we had durational alimony before, but we also had permanent alimony. And
when you say permanent, was it forever? If I got married at 21, I could get it till I'm 91?
So that's a bit of a misnomer. So, when we look at this bill as a whole, and if you look at actually, the existing, or the previous statute in the case law, permanent alimony basically went till someone retired, essentially. So you still had a right under permanent alimony to retire at a reasonable age for your profession. So, but the thing was, when you reached that age, you had to file what we call a modification. So you had to file a modification of alimony to ask the court to reduce or eliminate your alimony. And, the court could also consider at that time if you had passive income, if you had, investments and things like that. Even if you weren't pulling off of those investments, if there was generating a rate of return, that return could be considered income to you for alimony purposes. So that's where, people who were high earners, during their career, like doctors, you retired, you have a nice retirement, but now you can't really modify the alimony because you still have a good rate of return off of those investments. So that's probably the biggest change there. So it wasn't really permanent. You could eliminate it or modify it when you retired, but it could be difficult depending on your circumstances. So this basically got rid of that. You can just get alimony for a specified period of time, and it will end at some point. And so basically under the new law, the length of marriages has changed before, where anything between 7 and 17 years before used to be considered a midterm marriage. Anything under 7 years was a short-term marriage, and anything over 17 years was a long-term marriage, which entitled you to permanent alimony. That's all out the window now. So now basically a short-term marriage is 0 to 10 years, midterm marriage is 10 to 20 years, and a long-term marriage is 20 plus years.
All right, I'm in the midterm marriage myself right now, Mo.
Well, you're not in the worst case yet.
I still got a few years to go.
Yeah, and so basically, the court has discretion here still, so it's important to say that. But on a short-term marriage, they can get half the length of the marriage. So if you're married, 10 years, let's say, then you can get up to 5 years of alimony. But that's up to. It's the maximum. It's not that the court has to do it. They can do less if they want to, but it's up to 5 years. And if there's extenuating circumstances or compelling circumstances, they can actually go beyond that if they want to as well. But for short-term marriages, 10 years, it's 50%. For midterm marriages, 10 to 20 years, it's 60% of the length of the marriage. And for long-term marriages, anything over 20 years, it's 75%. Now, of course, under this new law as well, the court can consider what age you should retire based on your profession. Basketball players are going to retire a lot earlier than an engineer.
Yeah.
So let's say you're 60 years old, you've been married 20 years, but you're going to retire at 65. The court can consider that as a factor when they're determining how much alimony to award. So even though, on a 20 or 25 year marriage, it's saying that it should be 75%. If you're near retirement age, the court may consider that as part of making an alimony award.
Was there some stuff in this new bill about adultery as well that maybe wasn't in the previous law?
So technically, adultery actually was in the statute before, but the case law that came out and clarified it basically overturned that and said that we don't really care about adultery, we don't care about misconduct. Florida is still, even today, a no-fault divorce state. The only time under the old law, under the case law, that you can consider adultery was if there was misconduct when it came to marital funds. So basically, if there was dissipation of marital funds, so somebody was spending money on an affair, buying a paramour or a girlfriend jewelry, taking them on expensive trips, things like that, you could pull that money back into the marriage, and basically the spouse would be entitled to half of that, essentially. So under this new law, it says that you can consider the economic impact of adultery, which I think they're really trying to say the same thing as what the case law said before, because that kind of makes sense. If somebody's spending a bunch of money on whatever it may be, expensive trips.
I'm saying a yacht. I'm thinking a yacht in my head. You buy your.
Oh, you're aiming high there. I haven't met anyone who's bought their paramour a yacht yet.
I'm in different circles than you are, Mo.
Apparently. So I know a lot of people point that out and they think that, this is drastically different. The way I'm interpreting it, I think it's actually going to be pretty much the same as the way the law was before. It's just now being clarified by the statute rather than being clarified by the case law.
Do you know if this new alimony law affected child support at all?
So the child support formula is the same, essentially.
Okay.
Now, when you're calculating child support, though, alimony is income for child support purposes. So it could impact it, indirectly in that regard. But as far as child support, it's still the same child support formula that we've always used, which is essentially the number of overnights you have, the incomes of each party, and then if there's any daycare or health insurance costs.
So I'm going to ask you this big picture question.
Okay.
Why now? Like, why did this alimony bill come up now this year, and why did it get passed? Because I think it has kind of gone in front of the legislature several times, and it got vetoed a bunch of times. Like why was this an issue this year? Or
well, I think this is either the third or fourth time that's gone, through the legislature, and it was actually passed, was it last year or the year before? And then Governor DeSantis vetoed that version of the bill. And the main reason he vetoed that version of the bill was because it had a retroactive aspect. And so in our office, we've been getting emails, a lot of emails actually, from prior clients basically asking, does this impact the alimony that I'm currently paying?
And the answer is
no. Unfortunately, it doesn't typically. So it's not retroactive because under the Constitution, that would impact your right to contract. So it would be the government modifying a contract that was previously entered into, and so that's unconstitutional. And so that's why he vetoed the previous version of the bill. This bill will apply to basically any cases that are still in the court system at this time.
So if you had permanent alimony on June 1st, you likely would have it still.
You'd still have it. Now, the terms for the modification have changed a little bit as well. We can talk about that. So you'd still have to file a petition for modification if you have a basis to do so. And that's usually going to be a substantial change in your income, that you're at or near retirement age. One of the nice things under the modification statute that this bill did was, there was always kind of this gray area when someone was about to retire, whether they had to actually wait until they physically retired and stopped getting a paycheck to file a modification, or could they file a modification in anticipation of retirement. And so what we used to kind of tell people is, when you're about to retire, whether it's 3 or 6 months prior to retiring, go ahead and file the modification, because even if the other side moves to dismiss it, by the time that gets heard, you'll already be retired and you preserve the issue. And that way there's no gap where you have to continue to pay the alimony, even though you're not receiving income. Well, the statute now says that you can actually file the petition for modification 6 months prior to you retiring, as long as you actually intend to retire. So it kind of helped that situation there. But if you're currently paying alimony, you can file the petition for modification. But again, you have to have a basis to do so. That basis is going to be a substantial change in circumstances that was not anticipated when the final judgment of divorce was entered in your case. So that usually means that your income has been decreased substantially, you've retired, you've lost your job, something along those lines.
We should have mentioned this at the beginning, but if you have questions about divorce, you can go to DeWittDivorce.com. Mo, you wrote a whole book about divorce.
I did, and now I need to change the book because the law changed, so we'll be updating that as well. But we are getting some information about the alimony bill up on the website as well, DeWittLaw.com, so you can view it there, and of course, we'll still be talking about it here on the show.
All right, so real quick with this new law, who would you say it benefits and who would you say it's a detriment to?
Well, I want to be careful on answering that question, but it really just depends on the circumstances, frankly. A lot of people think, obviously, it's going to hurt people that receive alimony, that they eliminated permanent alimony. But again, people could always modify alimony. So I think, looking at this overall, hopefully, we haven't really seen it in practice yet because, it just rolled out on the 1st. So we haven't had cases that really have been awarded alimony under this new law yet. But hopefully it will streamline the process a little bit where there won't be as much discretion or question when it comes to the length of the term of alimony. And a lot of times before, what we would do, even when we were in mediation, is we would try to negotiate an end date to alimony. So even if it was a long-term marriage over 17 years, we would basically try to negotiate in our agreement that says, hey, once the person paying alimony reaches the age of 62 or 65, the alimony will automatically terminate. So that was the way it was dealt with a lot of times before. However, because the other side really had no incentive to agree to that.
I was going to say, why would you agree to that?
Well, because number one, the person can file a modification once they retire. That's another lawsuit that's going to be brought in the court. It's going to cost everybody more money. So that was one incentive to do it. But usually to get somebody to agree to that, you'd have to give up something else. Pay a little bit more money here or give them, something else they wanted. It's horse trading. So you got to trade something to get what you want. So, now that's kind of been streamlined. That's kind of been eliminated before. But again, a lot of the results we got before, I think, are going to still be the same even under this new law, because I don't think in practice it's going to change things quite as much as people think it will.
I read some stories on this, and it sounded like the people that were really against this were, just from the stories I read, were mostly maybe older women who had been married a long time. And it doesn't sound like they're the ones that are going to lose this. It would be people maybe who have been married for 20, 30 years and were maybe getting divorced or in the process of getting divorced like now.
Well, yeah, potentially that, if you're 62 years old, you've been married for, let's say, 25 years and you're looking at getting divorced now, potentially that could impact you because they're close to retirement age. But again, even under the old statute, under the old law, the person could bring a modification once they retired and then basically either eliminate the alimony or reduce the alimony. So while, on its face, maybe it sounds like there's a drastic effect there, I don't really think there is in practice. It just kind of streamlines the process where, okay, the court's going to say it's going to end at retirement age as long as he actually retires versus having to go back and modify it. Now, the one gray area I could see here is, the court awards alimony, for 3 years until he turns 65, but the person doesn't actually retire. And then what do you do?
All right. Well, Mo, we got to take a quick break.
All right.
We're going to answer some questions. We're going to answer some of your questions after the break. And if you do have questions, send those questions to ask@DeWittLaw.com. DeWittLaw.com. We will be right back.
All right, the crash happened. I was at a stop. The car was coming in, rear-ended me from behind. I was trying to get out of the way, but yeah, that didn't happen. Yeah. After the crash, I kind of sat down for a couple minutes, gathered my thoughts, after the ambulance and stuff. Got discharged, went home. I was really trying to think about what to do next because, that was my first accident. Of course, you hear all the time, call an attorney. So I wasn't really sure what route. I reached out to a friend of mine and she was just like, hey, I have someone you can reach out to. And she said, just call Moe.
Many of our clients are referred to us by friends and family, just like in Jamal's case. It was an honor to be able to represent him and ultimately fight to get him the compensation that he deserved.
My experience with Moe was really good. His team, his staff, very informative. I received all the information I needed, step by step. They made sure I was satisfied with everything, and everything has been really good. They're very detailed. They're very, they call or text whenever they make a move or whatever they're doing. They're mailing out a letter, anything. I'm always in the know, so that's really good on their part. So yeah, if a friend or family member, anyone would ever ask me if they need an attorney, I'll always say, just call Moe.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on the show, we talk about legal issues in Florida and how they affect you. I'm John Bustecker, and I'm with attorney Moe DeWitt of the DeWitt Law Firm. If you have legal questions, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. You can also call the DeWitt Law Firm at 1-800-DeWitt-Law. Moe?
John,
How was your break?
got some water. I'm good to go.
All right. So we're going to keep talking alimony because we got some questions about alimony.
We've got a lot of alimony questions lately.
We do.
Understandably, given the state of the law.
I mean, when things change like that, drastically change, people got questions.
Yeah, absolutely.
All right. So this is a question from one of your former clients, actually. So he says, I live out of state, and I saw that Governor DeSantis changed the law. It passed the legislature, and he signed it, but we know what you're talking about. Changed the law regarding alimony and wondering if it affects the way I do my alimony payments.
So it won't. So if you're currently paying alimony, you're going to pay them in the same manner or fashion that you've paid them before. However, like we talked about in the last segment, if you're getting near retirement age or if there's a substantial change in circumstances, then it may change the way that you file for the modification or when you can file for the modification. So that's really how it's going to impact people who are currently paying alimony. Unlike the old version of the bill, which Governor DeSantis vetoed because he deemed it to be unconstitutional, it's not retroactive. This bill is not retroactive, meaning if you're currently paying alimony, it's not going to impact the way you're currently paying alimony. You're going to pay alimony the same way.
Okay. And we actually got two questions like that. Same thing. This person's been paying it for 10 years. No changes for that person as well.
Right. Yeah. Again, unless you're getting near retirement age or you've had a substantial change in circumstances. Otherwise, it's basically going to be the same thing.
And if you were to come in for a modification, you can't say, well, the law has changed a bunch. I want a modification. Can you?
Well, no, you can't.
No.
You have to have a different basis to modify. You can't just say the law has changed. There has to be some substantial change in circumstances like retirement or, involuntary loss of income or something along those lines, where you could come and ask for a modification. You can't just say, I want to modify because the law has changed. But if you do have a divorce case that's currently pending, that's in the courts right now, even if it's ongoing, the new law will impact that divorce case. So it basically applies to any case that's currently open and filed where a final judgment has not yet been entered.
Well, this is the follow-up question that was not sent to us. Because you do family law, Moe, were people waiting to see what was going to happen on July 1? Like if you had a case that was set for, June 20th, you say, hey, let's try to push this back 10 days to see what's going to happen.
I mean, people were definitely curious. Obviously, this has gone through the legislature so many times that we didn't really know where it was going to go or if it was going to get passed until it got passed. Because we've had it passed before. It's been vetoed. It's failed a few times. So it's kind of difficult to say. Everybody who's certainly watching it However, in family law cases, the court systems are typically pretty slow. I mean, the courts are overloaded and backlogged anyways, to where it's kind of hard to change the time frames too much like that. But certainly everybody was somewhat curious as far as how this would impact things. But again, in our day-to-day negotiations, a lot of what the bill says now is kind of how we negotiated divorces previously anyways. So the overall impact is not nearly as great as I think people anticipate it being. Obviously, the elimination of permanent alimony is a substantial change to the law. But like I said, even under the old law, you could go back to modify it, ask for it to be eliminated. The biggest thing is that you now get an elimination date off the bat, so you don't have to file that second lawsuit and go through the court a second time.
All right. Let's pivot away a little bit from alimony. I got a question. This is from John, awesome name, in Orlando. I was in a car accident recently, and the other driver was at fault, but they don't have insurance. What can I do in this situation, and what are the legal implications?
Well, yeah, you can probably guess my answer on this one at this point, but number one, you should have uninsured motorist coverage for this reason in Florida. Florida is the only state in the nation, I believe, where you can legally drive on the road without any bodily injury coverage, which means that you can legally hit somebody and hurt them and not have insurance coverage to cover them, which is why uninsured motorist coverage is so important. Now, for the person that hit you, they can still be financially responsible, and if you have uninsured motorist coverage, your insurance company will typically sue them personally to recover some of the money they had to pay out, which could result in the suspension of their driver's license and other things. So it's a good idea to have not only uninsured motorist coverage, but to have bodily injury coverage, because it can lead to a lot of headaches down the road if you don't.
All right, Mo, we got to take a quick break, but don't go anywhere. We got a lot more questions that we got to get to, and we'll see you just after this break. Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on the show, we talk about legal issues in Florida and how they affect you. I'm John Bustecker. I'm with attorney Moe DeWitt of the DeWitt Law Firm. If you have legal questions, send those questions to ask@dewittlaw.com. That's ask@dewittlaw.com. You can also call the DeWitt Law Firm anytime at 1-800-DeWitt-LAW. That's 1-800-DeWitt-LAW. Mo, we get lots of questions every single week, and you do your best to answer them.
We try.
Not we, you try. I just sit here and ask the question.
I had to give you some credit. You show up at least.
I do show up. I do make sure that you get these questions answered, but you're the brains behind this operation at the DeWitt Law Firm.
That's scary.
All right, Mo, I got lots of questions for you. You ready?
Yep.
All right, so this is from Sarah. Sarah lives in Winter Park. Sarah says, I'm going through a divorce and I'm concerned about how our assets will be divided. Can you explain Florida's laws on marital property and how they might apply to my situation?
Sure. So, I mean, it's a somewhat simple and complex answer at the same time. I mean,
sounds like a lawyer way to answer that.
That's all I do on this show. Basically, anything you acquire during the marriage is going to be split 50-50. So, a lot of times people say, well, I made more of the money during the marriage. I paid, for more of this, or, I had, since my income was higher, I paid for 80% of everything, so I should get 80%. Doesn't work that way. Florida law basically says, you guys entered into a legally binding contract to be married, and so anything you acquire, by the efforts of one or both parties is going to be split equally. And there's some reasons to do it from a practical standpoint as well, where if, the courts literally had to sit there and determine how much each person put into every single asset, divorces would last 10 years. I mean, they would never end. So, basically anything you acquire during the marriage is going to be split 50-50. Now, there are some exceptions to that. So, the most common exception is probably an inheritance. An inheritance is a non-marital asset that belongs solely to the person who inherited it, as long as you don't commingle it. And this is where people get into a lot of trouble is they'll get an inheritance, they put it into their joint bank account because that's just where they put their money.
Yeah, that's what they've always done.
Well, now since you put it into a bank account with both parties' names on it, there's a presumption that it is marital. Because you took non-marital money, you put it into a joint bank account with both names on it. Now, sometimes if you can kind of trace back the money, if it was maybe only there for a short period of time, then you moved it into a separate account solely in your name, maybe you can kind of say, okay, well, that money just passed through the account. But, the more you move and commingle money, the harder that becomes. So, I talk about this in the book, and I got this from a judge in town, actually. One of the best definitions I ever heard of commingling is basically you take 2 eggs, you crack them, you put them in a bowl, and you whisk them together. You can't tell one egg from the other anymore. And that's what starts to happen when you put non-marital money into a joint account. Well, now you're going to the grocery store and you're buying money, your paychecks are going in there. You can't identify which dollars are which anymore because it's all just kind of been, combined together. So that's essentially what commingling is. And that's where you can get into a lot of different disputes in a divorce. The other major issue when it comes to equitable distribution in divorce is valuing the assets. So it's not so much that people are going to argue that they should get more, even though they argue with me about that. You can't make that argument to the court because there's just really no dispute in that in most cases. The argument becomes, well, how much is the item worth? So you think the item's worth, or the house is worth $300,000. Your spouse thinks it's worth $400,000. So then you have to get appraisals done.
Yeah. I mean, there's a fair market value to houses, though.
There is, but, especially when the real estate market was going crazy around here, 1 week we'd look up the house and it'd be 300, and then the next week it'd be 350, and then,
take the second week on that one.
Right. I mean, just depending, what houses sold in that area could drastically affect those appraisals, and you get an appraisal before trial. It takes 6 months to get to trial. Well, the house has gone up $100,000, in the right market, obviously, if there was the proper sales around. So it can still be somewhat subjective in those types of situations. Now, obviously, if one party believes the house is worth $400,000, you believe it's worth $300,000, you say, well, you buy it for $400,000. If they don't want to buy it, then it's probably not worth $400,000. So those are more of the disputes that you get when it comes to equitable distribution is, valuing the assets, and then how do you divide the assets? Because even though we divide an asset in a divorce, if there's a liability or a debt associated with that asset, we have to make sure that gets paid. So, houses, typically if you're getting a divorce, you don't want to stay on the house. If both people are on the mortgage, you don't want to both be on the mortgage after the divorce goes through. So you have to refinance the house. So then there's the aspect of, just from a practical standpoint, can one of the parties afford to refinance the house in order to keep the house? Or if they can't, then you really do have to sell the house in most cases. Now, sometimes people get creative, and I don't really recommend this, but sometimes they'll say, oh, well, we'll both stay joint tenants or co-tenants of the house until the kids graduate from high school. And we've had some nightmare divorces where we've seen what happens.
I can see where that doesn't work out so well.
Yeah, I mean, that creates a lot of disputes down the road, but sometimes, people want to do it for the kids and they can do that. But then, of course, down the road, once the kids graduate from high school, then you have to sell it and figure out how to split the proceeds from that, and that can be difficult as well.
So, Mo, I've never been divorced. I am married. I've never been divorced.
Just bragging over there, John.
Well, no, but my question is, I get when it comes to like houses and cars and like things of a lot of value, but what about when it comes to like just the everyday stuff that you have and even the stuff that's not valuable? And what I mean about that is like pictures or photographs or artwork, and when I say artwork, not like expensive.
I know your house is full of Picassos.
But like I think about my own house, and if I had to like divide it up, like does my wife get that thing and I get that thing? We just have like a draft and say you get this, I get that, or how does that stuff work?
I mean,
out?
somewhat. So the courts really don't want to deal with personal property. So usually we're relying a lot on the people who are getting divorced because they know what their personal property is to divide that up. And usually we make lists and we attach it to the divorce agreement. And so you kind of try to split things equally. Maybe one party gets one bedroom set, maybe the other one gets another bedroom set. Sometimes people say, I don't want any of it. I'm going to go get my own new stuff. I don't want to be reminded of you. I don't want to sleep in the bed that we slept in together. So I'm going to get rid of it. But, from just a practical standpoint, usually it doesn't make a lot of sense to use lawyers to divide up personal property because the amount you're spending on the lawyer, you can just go buy new stuff. So, just from a pure practical standpoint, it doesn't make sense. Now, a lot of times people get spiteful and they want to do it that way.
I could think of some stuff that, I could say, well, I've never used that, but, I'm going to say I want that just to
right.
be
You're going to say you want your wife's favorite thing in the house just to be spiteful.
Yeah. I'm not going to do that because I'm not getting a divorce, but
not yet.
I can see why somebody would do that in a divorce.
Right.
And just to be like you said, spiteful.
And that's where, we try to kind of counsel people and say, yeah, I get where you're coming from. I get you're upset, but just from a dollar and cents perspective, this does not make sense.
Okay.
It doesn't make sense to argue over, the rocking chair that, your wife loves because, she found out some antique store, when you can just go buy one for $100 and you're going to spend $3,000 arguing over this.
Okay. All right, Mo, let's move on to the next topic. All right. This is from Mike. He lives in Winter Garden. He said, I recently lost my job and my employer is refusing to pay me my last week of work. What are my rights in this situation and what steps should I take to ensure I receive my pay?
So you probably want to send them a letter to start, requesting the pay, but that can be a wage and hour violation. So if you actually worked those hours and you didn't get paid for them, it can be a wage and hour violation not only under Florida law, but also under federal law, which means that you can recover the wages that you're entitled to. And you may also be able to recover your attorney's fees for having to go after the employer to pay them. So, it's really in your employer's best interest to pay you on that because they don't want to have to pay your lawyer's fees as well. So I would start by sending them a letter, basically say, hey, you owe me this money. I worked these hours. These are the hours that I worked. This is the compensation I'm entitled to. And, if you don't pay me, I'm going to retain a lawyer and seek not only the amount I'm owed, but also my reasonable attorney's fees. And that way they're put on notice and hopefully they'll just pay you and that will be the end of it. But if not, you can certainly go get a lawyer and go after them for not only the money, but also the attorney's fees, which, I've dealt with these cases before, and the attorney's fees can be, quite significant when you're arguing over, $800 in pay. Then the employer gets a $20,000 attorney fee bill because they still refuse to pay it on top of that. That's not a good day for them. So it's really in their best interest to pay it, especially if they owe it.
That's good advice because I think some people might say, well, I'm owed $400, but, I don't want to go see an attorney because they're going to charge me, so many $1,000 and I'm probably never going to see that money. So I'm just going to not go after this $400. But you're saying it might be worth going after whatever, 400, 800, 1,000 because the other person might have to pay your attorney's fee as well if you win.
Right. So that's one of those cases where a lot of attorneys may take on a contingency fee basis where they get paid if you get paid, essentially, because there's a prevailing fee statute in Florida and other federal law as well, where you can basically be awarded attorney's fees. So it doesn't cost you anything to hire the attorney, and the attorney can go after and try to collect the money that you're entitled to.
All right, Mo, next question. This one might stump you. I don't know if you're an expert on this. This is from...
not an expert on anything.
That's true. Lisa in Lake Mary, she said, I'm considering filing for bankruptcy due to overwhelming medical debt. Can you explain the process, potential consequences, and any alternatives that might be available?
Well, I would say bankruptcy is a last resort, a last option. Depending on how much the medical debt is, a lot of medical debt, they're pretty willing to work with you on, try to get on some sort of payment plan. So I would try to do that first, reach out to the creditor and see if you can work something out with them directly. If there's absolutely no way to do that, then it may be worth consulting a bankruptcy attorney. Again, I don't do bankruptcy, as to whether it would be in your best interest to file bankruptcy and whether you qualify for bankruptcy. But again, like I said, I always think bankruptcy is kind of a last resort. If you can work something out directly with them first, maybe you get put on some low payment plan or something like that. That may be in your best interest. Is
medical debt different than other types of debt?
Well, it's all debt, right? But it does kind of, my understanding is, again, this isn't my area of expertise by any means, is that it doesn't impact your credit quite as much as, a bankruptcy would or a foreclosure would. That's something a bankruptcy attorney would be better able to advise you on, though.
All right. This is from Robert.
All right.
Robert lives in Kissimmee. He said, my neighbor's tree fell on my property during a storm. Who's responsible for the damage and what legal steps should I take to resolve it?
So we've gone over this before. It's been a little while, but basically...
It storms a lot here.
It storms a lot in Florida. So typically, if a tree is overhanging your property, you can basically trim back anything up into your fence line. So if a neighbor's tree falls on your property, same thing kind of applies. You're basically responsible for anything back to your property line. They're responsible for anything on their property line. The only real exception to this is if there was what we call a dangerous tree on the property. Dangerous tree sounds quite scary, but
Lord of the Rings, there was
Yeah,
trees that walked around, Mo.
that's what I'm talking about. No, I mean, in this case, if there's a tree that's, dead or dying that needs to be removed, and you've put the other side on notice, hey, you need to get rid of this tree, they just didn't do it, and then it falls and damages your property, that's where they could be responsible for the damage that it caused. But typically, it's just, if it falls on your property, it was a healthy live tree, just happened because of Mother Nature, you're responsible for anything that happens on your property.
So could you just like cut it off at your property line?
Oh, yeah.
Say,
People do that all the time.
Really?
Yeah. I mean, obviously, it's the more neighborly thing to go over to your neighbor, say, hey, we need to get this trimmed back. You want to split the cost or whatever.
Uh-huh.
But a lot of times, if people don't agree, they just trim it back to the property line.
All right. All right, Mo. This is from Emily. She lives in Tallahassee, so she might be
Let's do
listening. Podcaster. Yeah. Or maybe she was traveling through Orlando and heard your show and wanted to send you a question. You can send those questions to ask@DeWittLaw.com. We get questions all week, so we'll read your question on air if you send it to us. All right, this is from Emily. She says, I'm a renter, and my landlord isn't making repairs. What can I do to enforce my rights? And what are my potential legal, what can I do?
Yeah, well, again, it's going to go back to your lease. So you got to look at the lease first to see what you're responsible for and what your landlord's responsible for. Now, depending on the nature of repairs, if they're repairs that make the place uninhabitable or not, you may be able to withhold rent or not. I would consult with a lawyer before you ever withhold rent to see if you can legally do that. But I always think the first thing is to put them on notice, written notice, though. Of course, you can call them and say, hey, this needs to be repaired. But it's much more effective, and it gives you a paper trail if you can put that in writing and send that to them, both regular and certified mail, so that they're on notice of the repairs that need to be made. If they still refuse to make the repairs, then consult a lawyer, see if you can withhold rent or if you can file an action against them. But again, it's going to depend on the significance of the repairs. If it's they're not replacing the light bulbs and they're supposed to, well, maybe you can recover the $20 for the light bulbs, but you can't withhold that from your rent. Mm-hmm. But if it's something that's going to make the house uninhabitable, there's no running water, there's no heat in the winter, something along those lines, and they're just refusing to make those repairs, you have to give them a reasonable amount of time, but they're just blatantly refusing to make those repairs, then that may be a situation where you can withhold rent and basically break the lease. But again, you're going to want to talk to an attorney before you ever do that. All
right, Mo, we got to take a quick break.
All right.
You get some coffee, hang out a little bit.
Not going anywhere.
I'm going to get a donut,
all right,
and we'll be right back.
So I got a call from a guy last night who was in a pretty bad car accident. He was behind a work truck, essentially. Some items fell off the work truck, went through his windshield, smashed up his windshield, and hurt his hand really bad. So the insurance company reached out to him right after the accident, and he was at first concerned about getting his windshield fixed. I know that doesn't make a whole lot of sense, but his hand was all banged up and really needed to see a doctor about his hand, especially because he does construction work and that's kind of his livelihood. But he was concerned about getting his car fixed, getting it back on the road so he could start driving. So the insurance company sent him some paperwork, and he signed it. And the problem is that paperwork was a release. So basically, he released the at-fault party from any and all liability for a little over $400, basically, which means he can never go after them again. So he called us to see if we can help them. Unfortunately, in this case, we can't help him. He released the other side completely, and frankly, there's nothing we can do. And that's why it's always so important that you speak to an attorney before you ever sign any paperwork with the insurance company. Worst case scenario is the attorney's gonna say, yep, you're good to sign it, good to go. Worst case, or best case scenario, it'll save you from something like this. So before you ever sign a release, before you ever sign any paperwork with the insurance company, reach out to an injury attorney. Most injury attorneys won't charge you a dime to talk to you and take a look at that and try to help you with it. Unfortunately for this individual, it's a little too late, but hopefully somebody else out there can learn from his story and hopefully avoid making the same mistake he did.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on the show, we talk about legal issues in Florida and how they affect you. I'm John Bustecker. I'm with attorney Mo DeWitt of the DeWitt Law Firm. If you have legal questions, we got legal answers. Send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. DeWittLaw.com. You can also call the DeWitt Law firm anytime at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law. Mo, are you ready for some more questions?
Let's do it.
All right, here we go. This is another question about debt, but it's a little bit different than the previous one we had about medical debt. This is from James. He lives in Gainesville. He said, I'm being sued for a debt that I don't believe I owe.
Sounds like a good defense.
How should I handle this, and what can I do?
Well, the worst thing you can do is not respond to it.
I did that one time, actually.
I see people do this all the time. They get some sort of lawsuit. They're like, I don't think this is my debt. And honestly, a lot of times what has happened is the debt's been sold to different entities. So, maybe it was your Chase MasterCard, but now it's, ABC Bank out of Delaware that you've never heard of before. And you just don't make the connection. You're like, that's not mine. I don't need to respond. Then they get a default judgment against you for not only the debt, their attorney's fees, their interest, everything else. Now you owe triple.
Okay.
And then they start garnishing your bank accounts and your wages.
No good.
So that's not good at all. So even though you think it's not your debt, and hopefully it isn't your debt, you still need to respond to the lawsuit. So, if it's not your debt, you can basically file, affirmative defenses or a motion for summary judgment and, outline that this is not my debt, or make them prove that it is your debt by going through discovery and saying, okay, where's the contract, the card holder agreement that had my name on it? Where's the application where I signed to apply for this credit card? Where's the voice recording that I maybe did that over the phone and authorized it? And you also have to look at those credit card agreements, because a lot of times, let's assume it was your debt, they'll sue you here in Florida, but the credit card agreement says that the lawsuit was supposed to be somewhere else that had a shorter statute of limitations, and I missed it. And so sometimes you can get thrown out that way. But the biggest mistake, and this happens way more often than you would ever think, is that people just get something, go, that's not mine. They don't respond to it, and next thing they know, they have some giant debt that they owe, and their bank accounts are being garnished. So
Mine was a little different. I just had a bill that I didn't think was mine, so I just didn't pay it, and then eventually it went away, which is also probably terrible advice. All right, here we go, Mo. This is from Karen. She lives in Pensacola. My gosh, we're spreading out all over the state with questions today. It says, my ex-spouse isn't paying my child support as ordered by the court. What steps can I take to get this child support?
Well, you want to file a motion for contempt with the court and basically put the court on notice that they're not paying the child support. And from there, there's a number of things that can happen if they still refuse to pay the child support and they have the ability to do so. Their driver's license can be suspended. Their tax returns can be garnished. Eventually they can even be put in jail if they continue to refuse to pay the child support. But you have to file the motions and go after them in court to bring the court aware, to make the court aware of it. Sometimes, if it goes to the state disbursement unit, they may already be aware of it. But depending on the county, your best bet is definitely to file that motion for contempt.
All right. This might be the last question, Mo.
All right, let's do it.
It's a doozy. I think you know a little bit about this. This is from Tim. He lives in Sanford. He says, I was injured in a slip and fall accident at a store.
Okay.
Can I sue? Pretty simple, straightforward.
Well, maybe. So, just because somebody slips and falls on your property, at a business does not necessarily mean that there's an automatic lawsuit there. You have to still show that the property owner, the person who ran that business, was negligent in some regard. So usually what that means is that there was a liquid on the floor for either an extended period of time or a reasonable amount of time where somebody should have cleaned it up and they didn't. Now, the other way they can be liable is if it was their employee who spilled the substance on their floor and didn't clean it up. So, in a situation where, you're at the grocery store and somebody spills something and then 2.5 seconds later you slip on it, it may be difficult in that situation to show that the grocery store was negligent by not cleaning that up within the 2.5 seconds. However, if somebody spills something on the floor and 5 minutes go by and 3 employees walk past the spill and don't do anything to clean it up, don't put any signs up, that may be where you're able to show that they're negligent. And that's why a lot of times with these cases, we're not only looking for surveillance video of where the actual spill took place, but where all the employees are. So are they just all hanging out in the back on their cell phones, not doing anything, or are they walking around the store? Did one walk right by it and not do anything? Well, then they may be liable.
All right, Mo. We got to go.
All right.
Good
Went
show
fast.
today. Good show. A+.
Thank you, sir. I appreciate
You're
it.
welcome. All right. So if you got questions, send those questions to ask@DeWittLaw.com. Also, you can call the DeWitt Law firm anytime at DeWitt Law. We are here every Sunday answering your questions and talking about all the things that are happening in Florida's legal community. Mo, I will see you